Welcome again in the next video of Prelims Current Affairs series. So today we will see very important fundamental rights related news from current affairs, December 2024. UP Madarsa Act 2004 is partially valid and states to regulate intoxicating liquor. So this thing specifically comes in our freedom of religion within fundamental rights. And it is about taxing powers of states and you can say fiscal federalism. Both news are very important. So let's see what Supreme Court have said about the UP Madarsa Act 2004. Supreme Court partially upheld the constitutional validity of the Uttar Pradesh Madarsa Education Board Act 2004. So actually there is a big struggle between, you can say, between different fundamental rights, states power related to regulations of minority educational institutes. So it's a big judgment. The Supreme Court partially upheld the constitutional validity of the Uttar Pradesh Madarsa Education Board Act 2004 while confirming the state can regulate madrasa education to ensure standards of excellence. So main debate यहाँ पे ये थी कि as it is part of fundamental rights, तो state की authority है या नहीं है to regulate, to interfere within the administration of minority educational institutions. तो इसमें सुप्रीम कोर्ट ने स्टेट के तरफ दिया है डिसीजन टू इंश्योर द स्टैंडर्ड्स ऑफ एक्सीलेंस स्टेट कैन रेगुलेट मदरसाज. So the law secured the interest of Muslim minority community in Uttar Pradesh. This is consistent with the positive obligation of state. What is positive obligation of state? Where state needs to do something to provide that specific fundamental rights. As in many fundamental rights, we read it like state shall not, these are negative obligations, that state is prohibited from doing those things. So there are some positive obligations. यहाँ पे सुप्रीम कोर्ट ने बोला है कि it is consistent with positive obligation of the state to ensure that students studying in recognized madrasas attain a minimum level of competency that allows them to effectively participate in society and earn a living. So स्टेट का रेगुलेशन कंसिस्टेंसी में है विद द पॉजिटिव ऑब्लिगेशन ऑफ स्टेट टू अफर्म दीज थिंग्स. देन सुप्रीम कोर्ट ऑब्जर्व दैट द एक्ट विच अलाउड द बोर्ड टू प्रिस्क्राइब द करिकुलम, क्वालिफिकेशन ऑफ टीचर्स and standards of infrastructure did not directly interfere the day-to-day administration of recognized madrasas. That is, if we want to say in a single sentence, that is secular aspects of activities can be regulated by state. जैसे standards of infrastructure maintain करना, qualification of teachers maintain करना, and curriculum decide करना, these don't come under the day-to-day administration thing. The court, while noting that minorities had a right under Article 30 of the Constitution to establish and administer madrasas and impart religious and secular education, said the right was not absolute. That means right under Article 30 is not absolute at all. Can anyone tell me about सिर्फ सिटीजन्स को कौन कौन से राइट्स अलाउड हैं? एंड वन मोर क्वेश्चन, एजुकेशनल इंस्टीट्यूट खोलना, राइट टू एडमिनिस्टर रिलीजियस प्रॉपर्टीज, इट आल्सो कम्स विद इन द फंडामेंटल राइट्स. Try to remember this fact that Article 15, 16, 19, 29 and 30. These are specifically provided to citizens only, citizens of India. Then important aspects enunciated by the Supreme Court while upholding UP Madarsa Act. The state interest in maintaining the standards of education in minority institutions is well understood, and the state may impose regulations, conditions for grant of aid and recognition. That means जो secular aspect है education related, ग्रांट ऑफ एड रिलेटेड, वहां पे स्टेट गवर्नमेंट रेगुलेशंस इंपोज कर सकती है. द कॉन्स्टिट्यूशनल स्कीम अलाउज द स्टेट टू स्ट्राइक अ बैलेंस बिटवीन इंश्योरिंग द स्टैंडर्ड्स ऑफ एक्सीलेंस, प्रिजर्विंग द राइट ऑफ माइनॉरिटीज, establish and administers its educational institutions. That is, it's kind of harmonious balance between state power, state's authority to regulate, and fundamental rights of minority institutions. Education in entry 25 of the concurrent list must be given a wide meaning. Education is in our concurrent list. It must be given a wide meaning. Though recognized madrasas imparted religious instruction, their primary aim was education, bringing them in the ambit of entry 25. That means जो आर्टिकल 30 ने पावर दिया है उनको टू एडमिनिस्टर टू ओपन दियर एजुकेशनल इंस्टीट्यूट, वो सेकेंडरी है. प्राइमरी कंकरेंट लिस्ट की एंट्री 25 है जहां पे एजुकेशन की बात हुई है. मतलब अगर मदरसा एजुकेशन प्रोवाइड करने के लिए खुला है तो वहां पे स्टेट की पावर एंड अथॉरिटी है टू रेगुलेट देम. दैट इज द मीनिंग ऑफ दिस जजमेंट. The top court set aside Allahabad High Court judgment that the 2004 Act violated Article 21A and violated the basic structure principle of secularism enshrined in the preamble. So most important thing in this news is, okay, करेंगे इस पे बात आगे. प्रोविजंस क्या है? हायर एजुकेशन वाज डिक्लेयर्ड अनकॉन्स्टिट्यूशनल. दैट मीन्स जो एलिमेंट्री एजुकेशन है दैट कम्स इन द एम्बिट ऑफ स्टेट गवर्नमेंट, while the university education and higher education comes within the ambit of UGC which is under center. तो उन चीजों पे जो स्टेट ने लॉ बनाया था उनको अनकॉन्स्टिट्यूशनल डिक्लेयर किया है. The provisions of the 2024 Act pertaining to higher education at the levels of Fazil and Kamil were in direct conflict with the provisions of University Grants Commission and thus unconstitutional. The Uttar Pradesh law had wandered into the center's exclusive domain under entry 66 of the union list. अब यहाँ पे बताइएगा कौन सी डॉक्ट्रिन यूज की होगी सुप्रीम कोर्ट ने जब स्टेट इंटरफेयर कर रहा है सेंटर के डोमेन में और स्टेट के उस एक्ट को अनकॉन्स्टिट्यूशनल डिक्लेयर किया गया है. स्पेसिफिक डॉक्ट्रिन है. You can tell that name in comment box. Then most important news from this topic is law validity cannot be challenged for basic structure violation. That means basic structure कोई भी normal statute, कोई भी normal law को उठा के आप उस पे basic structure doctrine नहीं लगा सकते हो. It is the most important judgment from this point of view. The Supreme Court in this context held that the validity of a law cannot be challenged for violating the basic structure of the Constitution. I have put a link of an article from the Hindu where you can read it in detail, the jurisprudence. A 3-judge bench headed by the CJI was responding to whether the basic structure doctrine can be applied to invalidate an ordinary legislation. Authoring judgment, the CJI said that the basic structure doctrine was made up of undefined concepts. Actually, it is very ambiguous thing. बहुत undefined concepts हैं, कभी भी add हो सकते हैं. Sometimes it depends upon whims and fancies of the sitting judges. तो उनके बेसिस पे नॉर्मल लॉज को अगर हम जज करने आ जाएंगे तो फिर बड़ी जुडिशरी में ऑलरेडी पेंडेंसी बहुत है, बहुत दिक्कत बढ़ेगी. It will hamper the efficiency of judiciary and legislature as well. So allowing courts to strike down legislation for violation of such concepts will introduce an element of uncertainty in our constitutional adjudication, said the Chief Justice. So what is the issue surrounding taxation of industrial alcohol? First topic, it is clear now. Two important points from this news. First one is state can regulate standards of education, curriculum, teachers qualification, I mean secular aspects of education within the madrasas and other religious institutions. That is one important point. And another one is every statute, every law will not be judged upon basic structure doctrine. So second important news within it is what is the issue surrounding taxation of industrial alcohol. This is very old case, as we all know. Liquor for intoxicating liquor for consumption purpose comes within the ambit of state's power. टू टैक्स इट, बट जो इंडस्ट्रियल अल्कोहल है, अल्कोहल के और भी यूजेस हैं ड्रग्स में, हॉस्पिटल्स में और फर्दर अदर केमिकल्स बनाने में एज अ रॉ मटेरियल, वहां पे स्टेट की अथॉरिटी नहीं थी। सुप्रीम कोर्ट में कई केसेस गए, 1990s से चल रहा था ये सब, सिंथेटिक्स एंड केमिकल्स लिमिटेड वर्सेस स्टेट ऑफ उत्तर प्रदेश एंड मैनी मोर केसेस। अभी सुप्रीम कोर्ट ने स्टेट्स के सपोर्ट में फैसला सुनाया है। एंट्री 8 ऑफ द स्टेट लिस्ट गिव्स स्टेट द पावर टू रेगुलेट द प्रोडक्शन, मैन्युफैक्चर, पोजेशन, ट्रांसपोर्ट, परचेज एंड सेल ऑफ इंटॉक्सिकेटिंग लिक्वर्स। तो इसमें सुप्रीम कोर्ट ने बोला है कि जो इंडस्ट्रियल पर्पज के लिए है वो भी इसी के एम्बिट में आएगी। दैट मीन्स स्टेट्स हैव कंप्लीट अथॉरिटी टू टैक्स अपॉन इंडस्ट्रियल अल्कोहल। Recent Supreme Court judgment on intoxicating liquor ruled in favor of states. Entry 8 of the state list in the 7th schedule of Constitution would include industrial alcohol within its ambit. It is the important news that we need to remember. It can be a question in prelims. As per the Supreme Court judgment, entry 8 includes alcohol such as rectified spirit, ENA, extra-neutral alcohol and denatured spirit, which are used as raw materials in the production of potable alcohol and other products. Then the center has traced its power. Entry 52 of union list, which said industries the control of which by union is declared by parliament by law to be expedient in public interest. So both two topics are clear now. मिलते हैं नेक्स्ट वीडियो में। Thank you.